If I get a doctor to admit during the course of his pretrial deposition that he was careless, that he departed from the standard of care, is your case over? Can we now go home? Can we now celebrate? You want to know the answer? Come join me in this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, your case is not over. Now, here's the scenario. You brought a lawsuit against your careless doctor claiming that he was, in fact, careless, that he departed from the standard of care. You are claiming that his carelessness was a cause of your injury, and you are claiming that your injuries are significant and permanent. All three of those things have to be present in order to go forward with your potential case. Okay, so let's say a medical expert has confirmed that you have a valid basis for a case. During the course of your lawsuit, I will have an opportunity to question the doctor whom you have sued. So now, this pretrial deposition, which is also known as an examination before trial. In pre-COVID times, this would typically take place in the defense lawyer's office in his conference room. Now, during COVID times, this takes place over a Zoom video call. So now, let's say because of the powers of persuasion, because of my powers of persuasion, because of my ability to hypnotize somehow the doctor through a Zoom video call, the doctor capitulates and he agrees and he says, yes, I violated the standard of care. I was careless. Or in other words, I was negligent. Now, you might be thinking, okay, great. The doctor has now admitted he was wrong. Yes, if I can get the doctor to admit that he was actually wrong in treating you, now you're thinking, okay, this is great. My case is over. The doctor has just admitted for the very first time after many years now of treating you. Now he has finally accepted responsibility and said, yes, counselor, you're right. I did something wrong to your client, Mr. Jones. Well, guess what? Your case is not over. What the doctor has just done, if I am somehow able to convince him ethically and morally to capitulate and to actually admit that he was careless, now I have to get him to admit a number of other things in order to get your case finalized. What do I have to do? I have to get him to admit, number two, that as a result of his wrongdoing, as a result of his carelessness or his negligence, he caused you injury. We call that causation. There has to be a link between what he did wrong and the injury that you suffered. If there is no link between the wrongdoing and your injury, guess what? He could jump up and down and admit all he wants that he was careless. But if that carelessness did not cause you harm and injury, guess what? You're not going anywhere. And now you're going to have to struggle as you get closer to trial and as you go to trial to get medical experts to come in to just contradict the doctor and to say just the opposite. That yes, his carelessness was in fact the reason why you suffered all these injuries. So now, during the course of the doctor's pretrial deposition, his pretrial questioning, I get to ask him questions, lots and lots of questions. The defense attorney is there. He's representing the doctor. He knows before I even start to ask my first question that the doctor is going to acknowledge and admit he did something wrong. But now, during further questioning, I ask him, Doctor, would you agree that as a result of your carelessness, my client, Mr. Jones, suffered significant harm and injury? Oh, no, I wouldn't. Excuse me? Your doctor tells me that his wrongdoing, that he has freely admitted to, did nothing to cause your injuries. So instead, I turn around and say, Doctor, explain to me then how Mr. Jones suffered these significant and horrendous injuries. And now the doctor's going to give me a long-winded explanation and answer about how he believes and why he believes my client suffered harm and injury. So the only way we are going to get the doctor to capitulate totally is if I'm able to persuade the doctor, ethically, morally, to say, yes, I was careless. I'm sorry about it, but I was careless. And now I have to get him to say, my carelessness was a cause of your client's injuries. And the icing on the cake would be if I could get him to acknowledge, yes, that your injuries, my client's injuries, are so severe, so significant that they are permanent and lifelong. That would be the icing on the cake. So just because the doctor turns around during the course of a deposition and actually admits that he was careless, that does not end your case. We would like to think so. You may think so, but the reality is no, I need all three elements necessary for him to actually admit that he was careless, that his carelessness was a cause of your injury and that your injuries are significant. Only then can we turn around and begin settlement discussions with the defense counsel and say, okay, counselor, it's time to pay up. We need to end this case now. So why do I share this quick information with you? I share it with you because a lot of people don't understand the implication of what it means if the doctor actually admits under oath during his pretrial testimony that he was careless. You know, I realize you're likely watching this video because you're enjoying the scenery. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at gerry@oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.